Hello, good morning everyone here in the United States, and good afternoon for those that are in Spain or elsewhere with a different time zone. First of all, we would like to welcome and thank everyone for being here with us today. My name is Juan Carlos Pereira. I am the Executive Director at the Spain-U.S. Chamber of Commerce, and we are going to spend the next hour talking about insolvency proceedings in the U.S. and Spain. Everyone knows that the pandemic has increased the number of companies in distress and brought important changes to the regulations. So we thought that it was a good topic to have an overview about the differences between the US and Spain insolvency regulations and focus on the steps that a foreign creditor needs to take to submit a claim against a Spanish or a US insolvent company. For that today, we have panelists that are experts in these issues, and we would like to thank them for being with us today. Before introducing them, I'm just going to remind a couple of housekeeping questions. So first of all, this webinar is going to be recorded, and we will share with all the attendees the link with the video so that you could watch it again and share it with other colleagues and people that might be interested in that. We will also share the contact information of our panelists just in case you would like to contact them directly for any question, any comment, or anything else. And also, and most important, we would love to hear your questions. So we will spend around 45-50 minutes talking and discussing about these topics, but you can also send your questions, and Katharine will take care of them, and we will address those questions probably at the end, but you are able to send the questions whenever you feel necessary during the whole time. In order to do that, the only thing you need to do is to go to the control panel that you have in your, probably in your right side of the screen, and click where it says questions. There it will open a box, and you just need to write there your question, and we will take care of that. Having said all of that, without further ado, I'm going to introduce you the great panelists that we have today. So from Holland Knight, which are the partners that make this possible today, we have Katharine Menéndez de la Cuesta, international litigation partner of Holland Knight, based in Miami. We also have John Monaghan, which is co-national practice group leader for the Holland Knight Bankruptcy, Restructuring, and Creditors Right Practice Group. He's particularly focused on representing major case participants, both US and non-US companies, in complex commercial insolvency and restructuring matters. And also we have with us today José Carles, co-founder of Cuesta Abogados, a legal boutique based in Madrid, Spain. He specialized in business recovery, restructuring, and insolvency proceedings. He's a member of the advisory board of the Restructuring and Insolvency section of Madrid's Bar Association. So I think we have the best experts in the market to talk about this. And now I leave the floor to you and Katharine to start the discussion. Thank you so much, and I'll see you later. Thank you.
Good morning, everyone. Thank you, Juan Carlos, for your introduction, and to the U.S. Spain Chamber of Commerce for hosting us today. The goal of today's webinar, as you explained, is to address some of the differences between the U.S. and Spain insolvency or bankruptcy proceeding with a focus on the pandemic. And we have a lot to cover, so we will go straight to it. Good morning, John and Jose, and thank you so much for agreeing to participate in this webinar.
Thanks for having me.
I would like to start with how the pandemic has impacted a number of insolvency proceedings that are pending, whether there has been an uptick or not, and why, and what measures the government of each country has taken, if any. And let's start with you, John. How are things in the US because of COVID-19 in terms of bankruptcy proceedings?
Well, from a insolvency practitioner standpoint, the COVID crisis has been a disappointment. Not only have bankruptcy proceedings not increased, they have decreased as compared with the same time period in 2019. In fact, overall, there's been a 31% decrease in bankruptcy filings. That includes both individuals and companies. But on the company side, there's a 5% decrease. So year to year, 2020 was less than 2019. There are a number of reasons for that. One is economic stimulus packages that have been put in place in the United States. There have been a series of government-backed loans that have propped up companies and individuals. So there hasn't been the degree of financial turmoil that one would have thought might have happened when the crisis first started. The second is that in the United States, there is no requirement to file, there never is a requirement to file a bankruptcy proceeding. And here, there's really two types of companies, right? Those that can hang on and those that have been so hurt by the pandemic that they will never recover and there's no means for restructuring. And in the United States, what that means is that those companies, restaurants, bars, non-flagged hotels, they can simply lock the door, turn off the lights, and go home. And that has been what most truly troubled companies have done. They haven't filed bankruptcy proceedings. They've just shut down and announced to the universe that they are never that they're never coming back. And then the third and final probably reason why there hasn't been a lot of any uptick in bankruptcy is there has been no creditor pressure. Usually corporate bankruptcies, company bankruptcies in the U.S. are driven by some form of pressure, a senior lender seeking to exercise its remedies. For example, either through taking control of the assets or bringing a lawsuit. Well, it's been very difficult to bring a lawsuit because most courts have been closed except for emergency undertakings. And most other creditor remedies have been subject to a moratorium. So there's been no pressure to force the issue. As a result, as I've stated, there has not been an uptick in insolvency proceedings in the United States since the pandemic started.
Wow, very interesting, thank you. And I think things in Spain may have been different, but for different reasons. So Jose, what are your thoughts on this?
Exactly, it was very interesting. In Spain, there has been no uptick in insolvency proceedings also, but it was actually something that came totally directed by the government because of royal decrees and laws that were passed during the pandemic. It's different in Spain from the U.S. because in here we do have the obligation to file for insolvency. So if there is a company that's actually not able to meet their payments, they actually have an obligation to file, and normally they have to do it within 2 months. What happened with the pandemic? Actually, during what we call here in Spain the state of alarm, which was the first lockdown in which mainly no one could do anything, not even go out of their houses from March to June of last year, the government suspended the obligation to file for insolvency. So for a certain period of time, it was not compulsory. And then time by time, the government decided to extend this suspension. Then it was until the end of the year, and then until March 14, and then again until the end of this year, 2021. So now companies in Spain have no obligation to file, which normally implies if you don't comply with that obligation, that there could be personal liabilities of the directors. So it's an important obligation. And the fact that it's suspended means that the companies could wait until the end of the year in order to do it. This means that in 2022, there will be a wave, or it's expected that there will be a wave, because there will be that obligation. Different from the US, companies here cannot just close the business, restaurants, for example, as in the US. When they do that, for example, even if they had no debt, they would have to liquidate the debt of the workers. And this is different from the US, but then there would be the debt of the liquidation of the relationship with the workers, and then an insolvency proceedings would be necessary. And about creditor pressure that you talked on in the US, normally in Spain, as this is an obligation, then there's the way of the creditor of going against the company and being able to file for the forced insolvency of a debtor. But well, as the obligation was suspended, this possibility of creditors has also been suspended until the end of the year. So well, we will start seeing forced insolvency petitions again in the beginning of 2022 if it's not decided that this is extended. And one small thing, compared to other European countries in which the obligation was suspended, if the viability of the company was proved, or if it was proved that before the pandemic there was no insolvency, in Spain we didn't have that requirement. So it could happen that there was a company previously or insolvent previous to COVID, and well, in the end they have no obligation until the end of 2021. We will see if courts afterwards will state that that was a fraud of law, and we will see the liabilities it could imply.
Thank you. John, you mentioned this idea of turning off the lights, and you also said that there are two types of companies who may do that and companies who may need to go through a bankruptcy proceeding and restructure. What about liquidation? When is it necessary? When is it as easy as turning off the lights, or a company needs to go to some sort of liquidation proceeding even when restructuring is not possible?
Sure. There's never a necessity to go to a bankruptcy proceeding to liquidate, but it is a wise thing to do if there is value to be realized for the benefit of all, including the creditors. So if there is an entity that has value in excess, for example, of its senior secured debt, or has value that can actually flow through more of the capital structure than the very top, then it would be a wise thing to use the Chapter 11 paradigm in order to liquidate the company. In the United States, under Section 363 of the Bankruptcy Code, sales can take place free and clear. Sales of assets can take place free and clear of all liens, claims, and encumbrances. So in order to make sure that you have the time and to effectuate those sales, and to actually go through the sale process that results in the realization of that benefit of the value of those assets, the bankruptcy filing is a very helpful mechanism, and it is, frankly, it's the purpose for more Chapter 11 cases than the traditional reorganization and restructuring is. Most companies in the United States that file Chapter 11 do so for the purpose of effectuating a sale. To test that proposition, just take a look at all of the retail cases that have filed in the United States. Almost all of them are sale cases. And what happens is that the Chapter 11 case gets filed. Upon the filing taking place, there is an automatic stay, effectively a moratorium against any action by creditors seeking to exercise their remedies. During that time period, the debtor company can undertake a sale process where they solicit offers for some or all of their assets. They then test the adequacy of the offer that they've received through a fairly well-trod path of bid procedures that subject any offer to overbids. If there are competing bids, an auction takes place. And at the close of that auction, the party that has submitted the highest and best bid that offer is brought before the bankruptcy court. The bankruptcy court, more often than not, approves the sale. And by more often, I mean almost always approves the sale, free and clear of all liens, claims, and encumbrances. Sale takes place. The funds come into the Chapter 11 debtor's estate, and then they are distributed in accordance with a waterfall that appears also in the bankruptcy code. Again, if you're keeping score, it's in section 507 of the Bankruptcy Code that sets forth the priorities of who has to be paid in full before it drops down to the next level in the waterfall, before it drops down to the next level in the waterfall, et cetera, until you get to the almost never realized situation where there's money for equity.
Right. So it seems that it makes sense when the company the entity has assets that are valuable, and so this may be a way of maximizing the value of those assets. When that's not the case, then the turn off the light option seems the most probably efficient, since there's little to liquidate.
Right. There's not a lot of market desire right now for wooden bar material, or for cups and saucers and glasses, or for laptop computers. So if you're just a restaurant on the corner of any city street, there is really no need for a Chapter 11. You just turn off the lights and go home, because nobody wants to buy what you have. But if you are a high-end retailer like Brooks Brothers, well, somebody wants to buy your name probably. Or if you are an oil company, exploration and production company that owns the rights, the mineral rights under thousands of acres of Texas land that just isn't worth pumping out today, it may be worth pumping out a year from now. And so speculators could come in and they might be willing to pay something for those rights. Those are the kinds of companies that are worth taking into Chapter 11. But a single location a tavern, it's just not a lot of reason to do that. We were involved in one case, for example, for a retailer. It was called Brideside. It was a 5-location retailer that, as the name might suggest, sold wedding dresses. Well, the wedding industry all but died during the pandemic. You can't have a wedding with 200 people in the same place. But nobody was all that interested in a bunch of clothing racks and old bridal gowns that nobody wanted. So they just turned off the lights, closed the doors, and went home.
Jose, why is that in Spain, this idea of turning off the lights is, other than having an obligation to file for bankruptcy, as you explained, there is a reason for that, and what type of obligations make this impossible?
Well, the thing is that the Spanish system itself understands there's an obligation, because when there's an insolvency proceedings, there's what you call in the U.S. a bankruptcy trustee, what we call here in Spain the administración concursal, which is a third party court appointed, so appointed by the court, who supervises the activity of the company, and would supervise if there's, for example, a sale proceedings, like John stated. There could be something, I guess not as fast as in the US here in Spain, but something relatively similar. But it needs to be done with the supervision of someone external appointed by a court, which gives more guarantees to the creditors. So in a way, if these people see that there was something wrong, like the accounting system was not well, or there were some transactions that were strange, or that maybe some assets disappeared, they can take some action and even request the personal liability of the administrators of the company, like the legal administrators or the fact administrators. So it's important because of that. And just to point out something, John said there are sales in the US, and it's one of the uses of the Chapter 11. One thing that actually COVID changed was that in Spain we never had what's called a pre-pack sale, which is that it's a sale of the business. It's prepared before the bankruptcy itself. So basically, when you file for the insolvency proceedings, you request the authorization for the sale itself, and it happened in like 20 days, like the authorization within the declaration of the insolvency. This was in a business that consisted on a language schools. So it made sense that a business like this would mainly disappear if the users of the clients of the business school found out. They would freak out, let's say, and maybe not contract any new services. So this way it was avoided, it was done very fast. So the previous clients didn't almost notice that there was an insolvency, and the new ones didn't notice and already entered contracts into with the company when it was saved by someone who put the money to buy it. So in this way, it was for the creditors of these companies, it was something good because it was actually a possibility that was didn't exist here before. And I guess the courts of Barcelona wanted to, you know, implement the law in a way that even if it's not allowed, it's a way of making business continue, which is one of their values.
You also mentioned, Jose, that the Spanish government has imposed a moratorium on this obligation to file, and this goes until now, December 31st of 2021. What happens with the debts of these insolvent companies in the meantime? They are not obliged to file, but I'm assuming they have some obligations and creditors. And so what's the situation in that regard?
Yes, this is a little bit similar to what John mentioned for the US, I think. In here, the creditor pressure is less than in normal times. It's like people are bringing claims, and there was actually a wedding company that was sued by someone, and actually it was the company that had to pay the bride for like the money back for the dress because the wedding didn't take place because of COVID, which from my point of view is a bit crazy, but it happened. So there are claims being brought, there are things happening, courts are working. But it's true that in a way, even if you obtain a ruling, you wouldn't be able to, you couldn't force it in a normal way, but you wouldn't be able to force the insolvency proceedings of the company. So you can start legal proceedings, but it's legal proceedings that declare that that money or that amount is actually owed. So it's not, you know, then you can enforce it, and then you could force the insolvency in 2022, and then there will be nothing. So in a way, intelligent companies will file even if they don't have the obligation, because filing is really a file for insolvency is a restructuring tool. So it's something that if it's used well, even if there's a stigma in Spain regarding an insolvency proceedings, like if it were something bad, it can be actually something good. It's okay, you pay and you get paid less in a certain time, but well, at least you get paid something, and in several terms, and the company continues. So it helps the activity of the country. There are, however, direct aids that are being granted by the government here in Spain to certain sectors that were affected. Imagine restaurants or hotels. So if they prove the turnover went down because of COVID, like in a certain amount, they can get access to this. So in a way, creditors will be able to get something out of this, but it's not that much the money that the companies themselves are generating.
But during this time, in the end, the creditors, they have to wait, essentially. They have no resource right now to force payment on the debts.
Actually, for example, some years ago, we represented some creditors of the companies of the group of Abogados, and we forced the insolvency petitions. And well, it was in the end, it didn't end up in an insolvency declaration because, well, it was settled and everything, so there was no problem. But in a way, the creditor can put some more pressure in there, because it's if not, I know you are not doing things well, and if there's an insolvency proceedings, I request the liability of the directors, and the fact that you did it too late is something that puts me in a better position. Even the law in Spain grants a priority in ranking for 50% of the amount that's owed to the creditor that forces the insolvency proceeding. So it's seen as if the company doesn't do the homework, if the creditor does it for you, and it's kind of hard to do it because these filings are it's hard to prove, but if you actually obtain it, you get this priority in 50%. So now this disappears. until the end of the year.
John, during the preparation of this webinar, you mentioned something that I thought was interesting, which is that sometimes the U.S., maybe because the process is simpler, or maybe for other reasons that you know better, choose the U.S. to liquidate or to file Chapter 11 petition. Have you seen foreign companies filing in the U.S. during this time?
Well, yes. In fact, 3 Latin American, South American airlines have filed in the U.S. during this time. There's Chapter 11, full Chapter 11 cases pending right now for LATAM, Avianca, and Mexican Air. And it is an easy, the United States has a very broad jurisdictional reach. It is literally the case that if a company has any asset, singular, any asset in the United States, it is entitled to invoke the United States Bankruptcy Court's jurisdiction for the purpose of restructuring its debt, or for the purpose of conducting a sale in accordance with Section 363 of the Bankruptcy Code that we were talking about earlier. In fact, Jose mentioned there is a famous case where the judge said, "I read the statute to say a penny a pound or a peppercorn, one of any of those, and you can come to my court." So the trend actually started probably, I mean, it's probably, I'm getting old, so it's probably 5 or 6 years ago now, maybe even longer, when there was a downturn in the maritime industry. And maritime companies came to the United States in large numbers. We were involved in particular with a company called XL Maritime. I mean, it had, its headquarters was in Greece. Its vessels were flagged, you know, Liberia, Marshall Islands, the flags of convenience in the maritime industry. But they opened a bank account in the United States, and they rented a lease space in the United States 6 months before they filed, and that was plenty to get them jurisdiction in the United States. And for those companies, they found that the restructuring paradigm that Chapter 11 offers was beneficial to their company to restructure their affairs. The risk of doing that, of course, is that when you seek to enforce the United States court's orders in other non-U.S. jurisdictions, you may get some pushback. Those countries that are signatories to the UNCTAD Model Code, the United Nations Insolvency Recognition Treaty, those courts of those jurisdictions will look first to figure out whether or not the orders entered from the company's center of main interest, or COMI. And it may be that those there will be some courts that will decide that there wasn't sufficient contact with the United States to enforce the orders in that court. But the benefits, the way that those orders are enforced, is that if those creditors have any assets in the United States, again, for the United States, for the debtor to invoke the United States court, they need any asset. If a foreign company has assets in the United States that is a creditor, if they don't abide by the orders of the United States Bankruptcy Court, then they can be held in contempt of the United States court. And if the United States court can reach the assets of the foreign company that are in the United States, it can compel, basically, it can compel recognition or compel the the creditors' adherence to the court's orders. The places where you run into trouble are with companies that have no contacts with the United States. I once tried to enforce a United States bankruptcy court order against a Chinese shipyard, and that didn't go well for me. They tend not to have a lot of assets in the United States.
Right. Well, moving now to a slightly different topic that may be of interest to our audience. If a foreign creditor is owed money by a Spanish or a U.S. insolvent company, what's the procedure to file a claim and follow up later in the insolvency proceeding? And we're going to start now with Spain, Jose. So please, what are your thoughts on this?
This actually has improved a lot in Spain in the last year. It's much more simple. there used to be a time in which you needed to file the document within the court and like the originals always, and like it took a lot of time. Now it can be done by email to the bankruptcy trustee, the administrador concursal. So basically, when insolvency proceedings is declared, then it has to be published in the Spanish Official Gazette, something we read every day, of course. So creditors should know that when they should either look at the Spanish Official Gazette or have a lawyer looking at it, so they know when the term starts counting, and they have a month in order to lodge their claims. And here it's quite simple. They have to attach the documents. If it's an ordinary claim, like a normal trade creditor, then that would be it. But then if interests or some other kind of less important debts, then those can be subordinated, or debts of specially related persons to the company. And then there could be other secured creditors that have a privilege on certain assets of security on certain assets of the insolvent company. So you need to state the contract where it comes from, the amount that's owed, prove it, and send it to the insolvency practitioner, or the court-appointed bankruptcy trustee, as you say in the U.S., and that's it. It's by email. So this is how you do it. And normally, foreign creditors also think, and how do I follow? Like what happens with it? Like in that you have to state the email in which you want to get a response. So before they have to file in court the report with the amount that's owed to you, they should send you to your email, so you could see when they actually recognized what I wanted, or there's a problem, and maybe in that case I need a lawyer or someone to find out what happened. And that's it, basically.
So it doesn't matter where the debt was originated or the source for that, as long as it is owed by the insolvent company.
Yes, that's it. It's the only thing is maybe because foreign creditors do not know this. There's a line that makes a big difference, which is the moment when the insolvency proceedings is declared. So from that moment on, as I say, business as usual works. It's yes, it's an insolvent company, but it should pay these due amounts as a normal company. Because there's one rule in Spain that contracts shouldn't be affected by the insolvency. If not, if the counterparty was owed money and could terminate a contract because of this, then we will have a problem. But you cannot make creditors, you know, to have the weight of basically being a lender and not a creditor. So from the moment the insolvency is declared, the system in Spain provides that they have to be paid whenever they provide new services or they sell new products, then they have to be paid. And the insolvency practitioner, the bankruptcy trustee, as they have to sign every request for new products or whatever, they will say, well, there's money enough, so I authorize that sale. So that's basically the case.
So you recommended that if someone has a debt with Spanish company that may be going into bankruptcy, they have to check the Gazette or get a lawyer to do it for them. Will they receive any notice or an email or a letter from the trustee or someone at the company to let them know that the company filed for bankruptcy? Is there a control, some sort of procedure? No.
It's as I said, in Spain, it's considered that publishing it in the Spanish Official Gazette, which is like, I don't know, when there's an appointment of someone from the public administration, it also goes there. It's like something no one normal would read. But, well, for example, Abengoa again filed for insolvency. Well, again, now filed for insolvency. There was a refinancing agreement of Abengoa. Abengoa is one of the biggest companies in Spain, and it's renewable energies, and it's well known abroad and in the US. They filed for insolvency in the end of February, and for example, it hasn't still been published in the Spanish Official Gazette. I understand it's because in this case, as it's a public company, the Spanish FSA, which would be the PNMV, is actually appointing the bankruptcy trustee. So as there's still no bankruptcy trustee, it would be not very intelligent to publish it in the official gazette, because then creditors wouldn't know where they have to address their lots of claims. So I guess it will be, for example, in this case, in the next phase, but more than a month will have passed since the moment the insolvency was declared. So it's normally for a foreign client to be nervous, like, did the term start? Did the term start? Did you already lodge the claim? No, don't worry, we still have time. But it's important to know when it starts counting. So I would at least tell clients or companies in the US to make sure when that date starts, and then they have a month.
Thank you. John, how are things in the US for creditors?
Fairly similar, with the exception about the notice. Actually, when a Chapter 11 case starts, a debtor has to simultaneously file what's called the matrix, and it is a list of the names and addresses of all of its creditors. And everybody who is listed on that matrix, all companies, all individuals, will receive immediately, as soon as it's filed, a notice of the bankruptcy filing will go out. And so all creditors will receive direct notice, all known creditors will receive direct notice of the commencement of the Chapter 11 case. The timing of when a claim is due thereafter actually varies from jurisdiction to jurisdiction. In most jurisdictions, a separate time will come down the road where the debtor will have to file a motion seeking to establish the bar date for filing proofs of claim. Some jurisdictions, you will get a notice on that day you get that first notice. It will tell you about the date that you have to file a claim. Some you have to wait for a little while. The debtor has to file a motion, and you will receive a copy of that motion if your name appears on the matrix, and it tells you what the bar date is. And then once the bar date is established, you simply have to fill out a one-page pre-printed form that basically says name, address, amount owed, reason, do you have priority, yes, no. And then you staple whatever support you have to the back of that proof of claim. If you're a simple trade creditor, like Jose was talking about, you staple the copies of the invoices to the back of the claim, and you send it to the place designated in the proof of claim. It's one of two places. It's either the court in smaller cases. In larger cases, almost always there's a claims agent that the debtor asks to employ, and the court allows it. And the claims will go back to that claims agent. I'm sure folks who are on this webinar have experience knowing. I mean, there's Epic and BMC and Donlin Rocano and KCC and a couple of others. So you send the claim back to that claims agent. The benefit of the second part of your question, Katharine, was how do you keep track of what's going on in the case? If it is a case that's large enough to have a claims agent, then each of those claims agents actually always maintains a website that's case specific. So you can simply click on the link that you'll get, and you can read every pleading that has been filed with the bankruptcy court. And many of the claims agents have the option for you to subscribe to the case updates. So you can ask for daily or weekly or monthly updates, and then automatically an email will pop on your computer that has the list of the case of the filings during the prior period, and you can click and review all of them. So it actually is quite simple for the, as Jose was talking about, for the sort of run-of-the-mill trade creditor who shipped goods and didn't get paid for it. It's a little more complicated for other types of creditors. So for example, if you are a secured lender that has advanced funds, if you hold a claim to funded debt that is secured by a collateral interest in the assets of the company. Some countries refer to them as charges, some refer to them as security interests. We in the US call them security interests. Then you have to be a little more more attentive than if you're a trade creditor who's simply looking to to collect whatever may come your way in the form of distribution. You have rights in the U.S. if you're a trade creditor to, quote, adequate protection of the maintenance of the value of your collateral, and you have to be active in the case to make sure that your adequate protection rights are honored. And if you actually shipped goods that were received by the debtor within 20 days prior to the commencement of the Chapter 11 case, then you actually you have a priority payment right. You are on par with the sorts of creditors that Jose was talking about, who provide goods after the commencement of the case, the highest priority. And there, if you have those goods that were received within the 20 days, or if you ship those goods that were received within the 20 days, you have to be more attentive because there are shorter deadlines for asserting those claims. So you do have to pay attention there. And the submission that you have to make generally is more complicated than just the check the box on the proof of claim and staple the invoices to the cover page.
Just to be clear, as John explained it very well, normally, but then you would rely on the information the debtor gives. When they file for the insolvency proceedings, they have to attach like a set of documents, and one of them is a list of the creditors with the emails of each of the creditors. So if you are lucky enough and you are included in that list as a creditor, you will get an email from the insolvency practitioner, the bankruptcy trustee, telling you you should file your claim. And well, now it's been more and more developed, and some bankruptcy trustees even give you a draft of how you should do it. So even if some creditors do not know a lot about Spanish law, well, at least they get an example of how to fill it in or something. But what happens sometimes is that, imagine that, I don't know, you are a creditor, you are suing the company, so the company doesn't understand that you should be included in that list, so then you are not included, even if you should, as what's called a contingent claim, which is something that can exist or not, depending on the result of that claim that's outside the bankruptcy court. But when it happens, usually, like, or more often than what you think, that some creditors are not included. So I will always recommend to follow the publication in the Spanish official gazette, just in case. So that's the 100% safe way to know.
And let me ask you, both of you, what if the creditor is not included in that list? Is that creditor protected in any way, saying, well, I was not included, I was never told, so I have some sort of, recourse, or no?
Yeah, there's in Spain, there's what's called the provisional report of the bankruptcy trustee. In there, they state the list of creditors, and if a creditor says I'm not there and I should be, then they have a term of 10 days in order to file a claim in order to be included. So there are lots of small claims within the insolvency proceedings, which are called side issues, in which there can even be a hearing, or if it's sometimes if there needs to be discovered or something, then there's a hearing. If not, then it's only documents that are filed, and then the court decides, and then it's the court who decides. So it's the first, let's say, the first person who states if a claim should be included or not is the bankruptcy trustee. If they say it should be included and no one complains, then they are included. And if someone says it's not there and they complain, then there's like a small trial, and the judge decides on that.
What about the U.S., John? Katharine, there are volumes written on that very subject. I mean, and there is about to be a volume written by the United States Supreme Court, we believe, on the subject. I'm not going to answer the question. I'm going to tell you the example. General Motors filed a Chapter 11 in about 2008, 2009, right in there, and it confirmed a plan of reorganization. Of course, General Motors sells automobiles, so they sold automobiles prior to filing the bankruptcy that had a defect that could cause car crashes. So they sold those before the bankruptcy. The bankruptcy happens, and this person's driving this car, and seems to be okay. And then General Motors sold all of its assets and confirmed its plan of reorganization. and the person's still driving his car and thinking he's doing just fine. The plan gets confirmed, and the defect all of a sudden causes a major car accident that injures or kills people. So there, as Jose said, there was a contingent creditor. And that contingent creditor did not get direct notice of the Chapter 11 case because General Motors had no reason to believe that that was a creditor. And yet they have grievous injuries as a result of allegedly as a result of General Motors putting defective automobiles in commerce. Is that person barred? Stay tuned, Katharine. We'll find out.
Wow. That's a wonderful example. Well, great. So we're going to move now to our, I think, will be the last topic, and then we will address a few questions we are receiving from our audience. And the third topic is about clawback. And it is interesting, and sometimes it gets complicated. Just for those of you who may not know, a clawback essentially allows a bankruptcy trustee to undo a transaction that the entity that is filing now for insolvency or bankruptcy performed or did, and get the money or property back for the benefit of the insolvent entities and secured creditors. And so generally the trustee will use this clawback provision if, for example, let's say that some creditors were paid first, or some property was unlawfully transferred out of the entity's name before filing for bankruptcy. And here I would like to hear your thoughts on two aspects. The first one is how the clawback system works in general in your jurisdiction, briefly, and which changes, if any, have been imposed as a result of the pandemic. We can start maybe with John. I don't know if you have thoughts on this. I'm sure you do.
Yeah, I tend to have thoughts on almost everything, whether they're correct or not. There are two types of clawbacks, basically two types of clawbacks in the United States. One is a fraudulent transfer, which is both an actual fraudulent and a constructively fraudulent transfer. Actual is a transfer with intent to defraud. Constructive is a transfer made for less than fair value at the time that the company was insolvent. I'm going to just leave that there because there have been no changes to that as a result of the pandemic. The second and more often seen sort of clawback is a so-called preferential transfer, and that is a transfer made by the debtor in payment or towards payment of an antecedent debt that was made within the 90 days prior to the filing of the Chapter 11 case. And that's it. There's no evil necessary. It really is just if some creditor got paid in the 90 days prior to the bankruptcy for old debt, then that money is at risk of coming back as a preferential transfer. And those lawsuits can be brought in the Chapter 11 case up to 2 years after the commencement of the Chapter 11 case. There are two things that I do want to talk about here. One is first is the impact of an earlier section of this webinar on the clawback issues, and then the changes that have come about as a result of the pandemic. First, we talked earlier about filing a proof of claim. Bear in mind that filing a proof of claim in the United States courts' belief subjects the submitter to the jurisdiction of the bankruptcy court for all purposes. And if you take a look at sort of other interpretations of other courts in other jurisdictions in other countries, if one files actually affirmatively seeks payment of a claim and then an order enters against them in the case where they filed the claim, most foreign courts will actually enforce that order. They find you subjected yourself to the jurisdiction of the court, and therefore you have to pay the clawback that you just were adjudicated to owe. If you don't submit yourself to the jurisdiction of the court of the United States and a default judgment enters against you, then you have a better chance of not having that order enforced in a non-US jurisdiction. So if you file a proof of claim, you are subjecting yourself probably to the jurisdiction of the bankruptcy court in the eyes of all courts. If you do not file a proof of claim, you have a fairly reasonable argument that you have not submitted yourself to the jurisdiction of the United States courts, and therefore, when the United States representative comes to your country, comes to Spain to try to enforce that clawback right, you have a reasonable argument that your court ought not enforce that particular judgment. Now, talking about the changes as a result of the pandemic, Congress did make one change to that clawback right. Many landlords in the United States are modifying their leases. They have given their tenants a moratorium on payment of rent for 2, 3, 4, 6 months. And then they've taken the rent that wasn't paid and they've allocated it on a monthly basis across the remaining term of the lease. So if, for example, in September, you paid, your lease called for a $100 payment, you can still pay it at $120 because you were making up part of what you didn't pay for the 6 months prior. And Congress in the United States, and it has been enacted, has stated that those late payments cannot be clawed back if they were a result of a lease modification that went into effect after March 20th of 2020. That's the one change to the clawback rights that has occurred as a result of the pandemic.
Excellent. Wow. Jose, how are things in Spain on that side, on clawback?
Well, it's I will use some of John's words and worries about the U.S. For example, in Spain, the claim is lodged before the bankruptcy trustee directly by email. The court is not involved. We do not have that problem of being subject to the jurisdiction of the court. It's just an act that's an out-of-court act. You submit a claim, so you are not accepting the jurisdiction of the court because you are not filing a proof of claim before the court. So that's different in Spain than in the US. So just for creditors to know. It's important to know that creditors may have a role in clawback actions because it's normally in Spain the bankruptcy trustee who actually brings these claims in order to claw back like assets. In Spain, creditors can actually tell the bankruptcy trustee. I believe this was, for example, this asset went out unlawfully of the state of the bankruptcy state, and then it should come back. And then the bankruptcy trustee has a term of 2 months in order to either file a claim, or if they don't, then the creditor could actually file the claim themselves. So in here, it's not normally the creditors who do it, but you have this strength in order to, tell the bankruptcy trustee, if I ask you and I request you formally to do it, now you have a term of 2 months to do it. So if you don't do it, you better analyze why and explain to me, because if not, it will be myself who will do it. It's true that then they have to bear the cost. So it's not the same that the insolvency or the bankruptcy trustee does it in the benefit of the whole creditors, and a creditor actually does this bearing the cost. So it should, I as a lawyer would tell them, it's either that this asset really allows to pay the creditors, or don't spend the money yourself on this. There can be costs of if it's won, and then the costs, then the creditor could get them back, but they would never know. It's a risk. And actually, in clawback actions in Spain, basically, it works when there are payments that should have been done after other payments and they were done before, or when for payments that were due before, the insolvent company gave a guarantee. So it was a claim without an unsecured claim became a secured claim. So there's also that's detrimental to the insolvency state, or because there are these assumptions or presumptions when there's an act that's subject to clawback. For example, acts that are related to especially related persons to the company, like the owners or the directors or the son of the directors or things like that. So even if there's a sale, so even if there's a price being paid, even if there's consideration, it's to a especially related party that may be subject to clawback. And then it should be proven that actually it was sold at the market conditions, for example. what COVID changed here was not really the regime of clawback actions. What it changed is it's related to what we said about the obligation to file. Clawback actions, the bankruptcy trustee can actually claw back acts that took place 2 years prior to the declaration of the insolvency. So if there's now no obligation to file, well, if I maybe were a company that did something maybe wrong, like in 2019, if I wait until 2022, then the 2 years before, I'm sorry, this act didn't happen in the 2 years before. So is this a fraud? Is it not a fraud? Is it that the system or these changes in the legislation actually allowed for it? But this is being very commented, and it's being said that the guarantees of creditors actually have decreased because of the pandemic, because of this regime. Because I think the government didn't really think about this, these implications, because actually no changes were included. But well, if you move the date when the insolvency has to happen, then you move the date of actually the clawback actions, the acts that can be considered.
Thank you. We have 3-4 minutes now, and I would like to ask one question to each of you. A question for John would be, is there any change by the Federal Reserve or the FDIC, the Federal Deposit Insurance Corporation, that you would have highlight that has had an impact in the number of bankruptcy proceedings that you have seen this year?
You've been doing, whoever asked that question has been doing their homework. Yes, in fact there is. Early on in the pandemic, the FDIC and the Federal Reserve changed the regulations that are imposed upon federally insured U.S. national banks. Prior to this change, if there was a payment default by a borrower from a federal bank, then the federal bank had to take action. That is, they had to reclassify their loan as troubled, and they had to seek to recover on the debt. That particular regulation was suspended early on in the COVID process, and still is suspended. So there is no obligation, with no pressure on banks to bring pressure on borrowers. There has been insufficient pressure on borrowers to generate additional Chapter 11 filings.
And Jose, the question for you is, someone is asking, if I understood correctly, those workers that were in ERTE, which is some sort of Spanish furlough, where workers are not definitely terminated, but they are only furloughed. These workers cannot be fired during 6 months after the end of the ERTE, or this furlough. How will the company address the issue when the ERTEs end, if they are still unable to maintain that worker? It's a very technical question.
No, it's actually, there start to be rulings, because the problem in Spain was that when you have workers on these, let's say, plans, in order to, like have them wait 2 months out of work, and then you don't really have to pay them, but then you get them back, which is what's called the ERTE, the ERTE, as you said. There's an obligation not to dismiss afterwards, but there was a limitation, which is that if the company actually becomes insolvent, then this limitation wouldn't work. So in a way, if the company cannot meet the payments, then this obligation wouldn't work. So, and there are actually I'm not a labor lawyer, but actually what I've been hearing is that even in cases when it's not the case that the company is insolvent, some judges, some courts have understood that the company cannot be taken away the right to fire someone because of a royal decree. So like this, because of the regulation of COVID of the ERTEs. So anyway, if the person who did the question wants to contact me, I will try to get the information of these rulings and say it much better than here.
Thank you very much. Well, thank you so much to both of you, Jose and John. It's been a pleasure. The conversation has been very interesting, I think, and I now return the mic to Juan Carlos. to wrap up.
Yes, hello again. Well, yes, thank you so much, everyone, for being with us, and thank you to all the attendees for joining us to this excellent topic. As a reminder, as I said at the beginning, this conversation has been recorded, so everyone will be able to revisit and share with other colleagues and friends. We will send the link of the video probably by the end of the day today. And also we will send the contact information of all the panelists so that anyone that might have a specific question, any comments that they would like to address directly to them, you could do that. So thank you so much for being here with us. Thank you to Holland and Knight for bringing us these great panelists. And I think that will be all for now. So Katharine, Jose, and John, thank you so much and have a great day.
Thank you, Juan Carlos. You too.
Thank you. You too.
Goodbye.
Bye.